So let's dive into a really fascinating Canadian Supreme Court case that all started with, believe it or not, a simple knock on the door. It's called R v. Evans, and it digs into a wild question. At your own front door, where exactly does your right to privacy end and police power begin? And yeah, that's the core question we're tackling here. It sounds kind of strange, right? Can a smell actually violate your rights? But this is exactly what the Supreme Court had to figure out. Could a police officer just using their nose at your doorstep actually count as an illegal search?
Okay, so how did this whole thing even get started? Well, it began when police got an anonymous tip that a couple, Cheryl and Robert Evans, were growing marijuana in their house. But here's the catch. A tip from an unknown person just isn't enough to get a search warrant.
You know, the actual police work here was pretty straightforward. They get the tip, they run some background checks, but nothing comes up. So they decide to do what they call a knock-on. They're just going to walk up to the door, knock, and talk to whoever's inside. But they had a little something extra in their plan. They also wanted to get a whiff of marijuana when the door opened. And wouldn't you know it, that's exactly what happened. They smelled it, and boom, they made the arrests right there on the spot.
Now, this one simple action completely split the Supreme Court. You've got one side, led by Justice Sopinka, and he's basically saying, whoa, hold on. What the police just did, that was an illegal search, and it violated the Evans constitutional rights.
To really get what he's saying, you have to understand this one key legal concept, the implied license to knock. It's this old idea in law that you've basically given an open or implied invitation for anyone, the mail carrier, a salesperson, a neighbor, to walk up to your door and knock. Why? For the purpose of communicating with you. But that purpose is absolutely key here.
And this quote from Justice Sopinka just nails his whole argument. He's saying that invitation is only for communicating. The second the police showed up with the intention of searching for evidence, of sniffing for marijuana, they broke the rules of that invitation. They weren't just acting like regular people anymore, they were acting as agents of the state conducting a search on private property without a warrant.
But of course, that's not the whole story. Not everyone on the court saw it that way. The other side, led by Justice Major, had a much simpler take. The police didn't do anything wrong at all.
So let's just put these two ideas right next to each other, because it's a huge difference in thinking. For Sopinka, it's all about what was in the cops' heads. Their purpose changed everything. For Major, that just doesn't matter. He says a police officer is just like any other citizen at your door, and what they happen to smell from that legal spot is fair game. You could call it plain smell, kind of like the legal idea of plain view.
See, Justice Major's whole point was that the police were just there. They were standing on the front step, a place any one of us is allowed to be. And his reasoning was, when you open your door to the world, you take a risk that the person on the other side is going to use their senses. You risk them hearing what you say, seeing what you're holding, and smelling what's coming from inside your home.
So you've got the court totally divided on this fundamental question. The verdict was anything but straightforward. So what on earth did they decide?
After all that back and forth, a tiny majority of the judges finally came to a decision on that first big question.
And boom, they sided with Sopinka. The court ruled that the police officer's purpose was what mattered. Because they went to that door specifically to find evidence, their sniff was a search. And since they didn't have a warrant, it was an unreasonable search that violated the Evans charter rights.
Okay, so that seems simple enough. The search was illegal, which means all that evidence, all 41 of those marijuana plants, it has to get thrown out of court. And the Evanses walk free, right?
Nope, not even close. This is where the case takes a huge, surprising turn. Even though the court found a serious constitutional violation had happened, they decided to let the evidence in anyway. The conviction was upheld. You're probably thinking, wait, how is that even possible?
Well, the answer is buried in a really interesting part of Canada's Constitution called Section 24(2) of the Charter. It's basically a safety valve. It says that yes, normally illegally obtained evidence gets tossed, but it can be allowed in if kicking it out would do more harm to the public's faith in the justice system than letting it in. It's a balancing act.
So the court uses this three-step checklist, basically. First, did using the evidence make the trial unfair? They said no, because the plants were real, physical evidence that existed long before the police showed up. Second, how bad was the violation? They figured it was pretty minor, because the police honestly thought they were following the rules. And finally, what's worse for the system? They decided that letting people get away with a pretty serious crime would be more damaging to public trust than allowing the evidence in this one time.
All right, so after all that, what's the takeaway? Why are we still talking about this incredibly complex case today?
It all boils down to this really weird paradox. This case, R.V. Evans, set a hugely important rule. Your front door is a constitutional line. Police can't just cross it to go on a fishing expedition for evidence. That's the principle. But it also gave us a powerful reality. If they do cross that line and the court doesn't think the violation was too bad, the evidence they find could still be used to convict you.
And that really leaves all of us with a huge question, one that's still relevant every single day. The Supreme Court tried to draw a clear line with this case, but it's a line that can feel pretty blurry. It forces us all to think about that little space on our own front porch and wonder, where exactly does the safety of our home end and the power of the state begin?